can make it as convenient as possible because I know people have to work in the morning. And with that, Clyde, what you got?
People speaking up so we can hear from back to all the ask questions and even some of the speakers when they're not using the mics.
Sure. And I think we have a better mic setup today than the other room, so I think we're all right. And Jani, you have the mic here, so we're good. And so what we're going to do now is Jani Jo Woods' case law update. She's always very good at it. It's always very informative, and I'm looking forward to hearing it. So without further ado, Jani, take it away, please.
All right. I was trying to think of a theme to tell you, like what the recent case law is, but I didn't want to depress you, but it's pretty much you're out of luck. And I tried to find like the pearl among a lot of other things, and we might find a few cases. But what I would encourage you is to listen to cases and you think, well, you know, that kind of the defendant lost, but how you can make it a little different, maybe put some more evidence on so you can use it for you. That's what I like to do. I like to use it against them sometime. It might take 10 years, but I come back. Anyway, so this is, and I have them sort of alphabetical by topic, so you know, and it's the Court of Criminal Appeals and the U.S. Supreme Court. I couldn't do all the courts of appeals. I think you'll be overwhelmed with just this. I know I was. Well, this was interesting because the state wanted the appellate judge recused. And the Court of Appeals in Fort Worth 4-3 said, no, she's not recused, which I could never find the document why they didn't want her. So the state PDR'd to the Court of Criminal Appeals, and the Court of Criminal Appeals, in their infinite wisdom, punted, said, no, you have to wait until the actual appeal is done. So there's no interlocutory right on a recusal at the Court of Criminal Appeals. Now you're thinking, I would never do that. Well, maybe we should. Some of them or all of them. I'm kidding. All right. Confrontation. Statements made by a child to their teacher was not testimonial because it wasn't considered for prosecution purposes. And this where apparently the little kid came to school and had a lot of injuries, and the teacher's like, what happened? How'd you get that? It's not for, you know, purposes anyway. So all that's coming in. So if you can find something wrong with the teacher later, I'm kidding. All right. I'm kidding. All right. DNA, this is sort of that McNeely bull-cumming issue, and so they had 3 different analysts testing different parts of the DNA, but they only had the supervising analyst come and testify, and this was a local case, Robert Morrow's case, and they objected, and the court was like, that's fine, because that person was actually there, present in the lab when the other 3 were doing their investigation, or their analysis. So if you're keeping track, that's another loss for the defense. If you you don't have enough fingers and toes today to include all the losses. This doesn't come up very often, but if they're going to add like a deadly weapon paragraph after your guy's been like sent to TDC on a nunc-pro-tunc, they can't do that. Like the entry of a deadly weapon, you need due process. The defendant has to be there. Doesn't mean they're not going to do it later. It just means he has to be there for the glory. All right, this is recent. I've updated the cases, including the hand down from 2 days ago. And it's still legal to burn a flag in Texas. But it was 6-3, so you never know how that's going to swing. But they held it, the statute's invalid on its face. I don't get many flag burning cases, but what I also found interesting, it's State versus Johnson, and for you history people, the U.S. Supreme Court was Johnson v. Texas. Apparently people named Johnson want to burn some flags. And actually this guy like burned it, if any of you have been out to the Ferguson unit in Lovelady, he like saw some cops drive by and he grabbed a flag off the side of the road and lit it on fire. It was like he was exercising his First Amendment right. All right, threats on social media must show an intent to issue threats. This was, and I found like the funniest little Facebook cat, because on Facebook the husband was writing some rap lyrics about how he was going to kill his wife. Yeah, you know, it was all in good fun. You know, he was being creative. Well, he got prosecuted for making these threats on Facebook, and they're like, no, you have to show an intent that he knew it would be communicated as a threat and not an expression of his raptitude or whatever. All right. This is another one from the U.S. Supreme Court where the guy was making like what some people might call bath salts, but he didn't know they were bath salts. He thought they were something else. And he put on all sorts of stuff like these are not, FDA approved, all sorts of to try and make it seem like he was following the law. But in this case, they said, well, you have to show an intent that he knew he was violating the law. And look, you're not going to win this on cocaine or marijuana or crack. But, something like bath salts where he's like, oh, I didn't know that was illegal. You have a little bit of a Supreme Court precedent. Oh, this one's awesome. This case, it's out of Montgomery County, and this lady got arrested, and her friend called the DA's office and pretended to be a DA from Dallas and said, would you be lenient with my friend? Because I'm a DA, and we're on the same team. It's like, dude, they can look you up. But anyway, the issue was, in asking her to be lenient was the second prong of the statute met in asking them to do an official act. So the court said, yeah, that's fine, because we don't want people pretending to be DAs, even if they are DAs. I'm kidding. All right. I'm really going to be uncensored today. I've spent a lot of time teaching for the Criminal Defense Lawyers Project, which is funded by the Court of Criminal Appeals. So my First Amendment rights are limited by who's having me there. But since Mark's having me here, I'll just say whatever I want. All right, death penalty. Yeah, the Supreme Court does not care if the executed person suffers pain. I know you might be surprised by that. I was. They don't care. And but what's interesting is Glossop. So he went up there, he lost on this, and if you follow capital litigation at all, Oklahoma has now suspended executions because they don't have the right drugs. Apparently it's very hard to get drugs to kill people. I don't know. And if you're very interested, their sister Helen, and she's speaking next Tuesday at Texas Southern. So she's a very inspirational speaker. That's right. I'll be there for lunch. All right, habeas. It is very hard to get hearings on habeas. For those of you who do writs in state and federal court, getting a hearing is hard. But on this case, because it had to do with his intellectual disability and an Atkins claim, the court yelled, yeah, you're supposed to give them a hearing. Oh, and if I had to pick themes for today, it's double jeopardy. The Court of Criminal Appeals is very interested in double jeopardy and how nothing is double jeopardy, and a lot about mental retardation in capital cases where they will find every way for you to lose. So, all right. In this case, it's interesting, the defense and the judge all agreed that they could have a hearing before the trial to determine if he had mental retardation. And the court held, okay, we'll let you do that because, we'll reverse it later. Kidding. And I'm very upset because the next case is ex parte Bobby Moore. And Bobby Moore's been around, probably a lot of you may have represented him at one time. He's gotten his case reversed off death row. He's on death row. But as I understand it, there were findings that he was mentally retarded that the state agreed to and that Judge Susan Brown signed off on. So you're thinking, oh, okay, that should be pretty good, because what is the rule of the Court of Criminal Appeals? We give deference to the trial court's finding. Well, no. No, they give deference if you're losing. If you're winning, there's no deference, and they said, we're not going to accept those findings because you used the wrong mental retardation standard. You used what the AMA uses, and you need to go back to Briseno, which we decided 11 years ago because we didn't have any statutes on how to determine mental retardation, and so you needed to go back and use that wrong standard. I kid you not. So, and I don't know, like after that came out, and I read it, I had to take a day off from work and lay in bed for 4 hours. I kid you not. I may have represented him in the past, and he's got some issues. All right. This is a case that ought to really infuriate all of us. You know, you get a lesser punishment on kidnapping if they let the victim go in a safe place. This child was kidnapped outside an apartment, and he returned her to the exact same spot. But they're like, well, that wasn't really safe. So it was safe enough for her parents to let her go catch the bus there, but not safe enough to return there. And I'd like to tell you how you can get around that, and the opinion will not help you at all. At all. Okay, double jeopardy. This truly, whatever you thought about double jeopardy, just assume it's not. Like, oh, it's not. So, indecency with a child by exposure and indecency with a child by sexual contact, not double jeopardy. Even though, I know. Yeah. Well, because like he exposed himself, then he touched her. Oh, all right. I might give him that with Turd Ferguson in there. All right. So what they're looking at, and this is in a capital case, and it has an interesting procedural background. It was a death penalty case or a capital case in San Antonio, and they used a general verdict. And so it was never proven what the qualifying circumstance was, like the murder, was it by burglary or was it by assault on someone else in the house? And so when it got reversed, they actually had to come back. And so what they're talking about is, in double jeopardy, you want to look at the units of prosecution. And you're thinking, okay, think of it this way. 2 people, 2 units. So it's not double jeopardy. We'll come back on the other person. Indecency by contact, we're not subsumed by acts of aggravated sexual assault of a child. So, you know, it used to be like, if you exposed yourself to have sex with a child, not good, but it used to be subsumed. And they're saying we're not getting rid of the subsumption theory, but in none of these cases that have come to the court does it apply. So people are getting really hammered with a lot of stuff, not just sex cases either. Now they can get you for intox manslaughter and felony DWI, not double jeopardy, even from the same transaction. I know, and if you look at the case and the cites in my paper, which you all will be getting, they talk a lot about, well, the felony DWI, those other DWIs are elements, and those aren't the same elements as in intox manslaughter. So just, they're really keen on taking away your double jeopardy. You know, you're right. It's like, no, we're going to get you for everything. All right. Pardon? I would assume for felony DWI, the way they've written the case. Oh, and here's the other thing. So this guy, this is an interesting case. He had 3 cases, some sort of fraud. He doesn't show to court twice. So they charge him with failure to appear and bail jumping in each case. So now he's got 6 new charges. Yeah, exactly. You're like, really? How does that happen? Apparently it does. And so his lawyer sort of objects and says, you know, that's kind of double punishment. But then on appeal, his appellate lawyer doesn't raise it. So then on habeas, he raises it. And they said, whoa, you're procedurally defaulted. You should have raised that on direct appeal. And so Judge Johnson wrote an opinion, and I can't remember that she concurred or dissented, but she was like, this is ineffective on the appellate attorney for not raising it. But typically the CCA has considered constitutional violations on habeas. So this is just really a mechanism for you lose. Oh, I'm sorry, was that depressing? I'll try and be more upbeat. Oh, this one is great. So your guy gets probation, and they order him to go to drug treatment. And then, stupidly, during drug treatment, he talks about how he killed a girl and buried her body. I know, it's like, you couldn't save that for your priest, but anyway. Well, so typically statements made during drug treatment are privileged, but it has to be voluntary drug treatment. And if you're ordered to go as a part of probation, it's not voluntary. Except I think the lawyer had a very good argument. It's like, look, you know, he chose to do this. He could have gone to prison. And he's like, this is a contract. This is all voluntary. And they're like, no. So, and again, if you've ever heard me speak, and you all heard this, bad facts make really bad law. So this is like, we've got to get that in. Because apparently he told a lot. He just could not stop being treated there. All right. Okay, this is an actual picture. See, that's a police officer with a beer can. And being passed out behind the wheel of a running car is now operating the vehicle. Yeah, so for those of you who thought it wasn't, the court says you're wrong. Even though he's not driving, he looks like he's resting comfortably. All right. Okay, Rule 901 allows a witness to sponsor evidence of text messages despite the witness's less than stellar credibility. And this is one, isn't that a great text message? I worked really hard on this PowerPoint. But, wow, that's fantastic. In this case, you know, they're like, look, that woman saying those are all text messages from him, she's not credible, she's a liar. And they're like, it doesn't matter. She's saying that they're from him. It's his phone number. He was responding to her. So basically, if that evidence can hurt you, it will be admitted. All right. Okay, this is one case where the defendant won. Yes. And this one's so obvious. So he filed a motion for an expert and a motion to inspect the evidence. And the court's like, no. He's like, Judge, I'd like to inspect these drugs. No. So he appeals, and ultimately the CCA says, well, you didn't present enough reasons why you deserved an expert, but you had every right to inspect the evidence, so it was reversed. So I would recommend that we all start filing motions to inspect the evidence. And you're thinking, I don't want to do that. It'll be fun, I promise. I'll help you. All right. This one is the old common law of tacking. And, you know, we don't use tacking anymore. We use the Rule of Evidence 609.